So let's talk about something that's often debated in legal circles: judicial oversight versus judicial misconduct. It's a really important question, especially when we look at how courts handle certain tenancy laws. There's this troubling pattern we've noticed: the systematic omission of Section 56 in eviction suits against Pagri tenants. It's honestly a detail that's frequently overlooked, but it has serious consequences. Now, what exactly does Section 56 say? Well, at the heart of the law, Section 56 of the Maharashtra Rent Control Act, 1999, directly affirms the legality and enforceability of compensation rights in tenancy transfers, especially under the traditional Pagri system. Here is the verbatim legal text. Notwithstanding anything contained in this act, it shall be lawful for I, the tenant or any person acting or purporting to act on behalf of the tenant, to claim or receive any sum or any consideration as a condition of the relinquishment, transfer or assignment of his tenancy of any premises. 2. The landlord or any person acting or purporting to act on behalf of the landlord to receive any fine, premium or other like sum or deposit or any consideration in respect of the grant or renewal of a lease of any premises, or for giving his consent to the transfer of a lease to any other person. So, what does all this mean in practice? Well, these provisions, they actually recognize the tenant's right to compensation when surrendering tenancy. At the same time, they also legalize the landlord's right to a premium when granting or renewing a lease. But importantly, they also imply that no eviction can occur without fair compensation, especially in protected premises. Now let's talk about a judicial blind spot while framing issues. When small causes courts or high courts hear eviction suits, they often fail to frame a critical issue: whether the landlord has complied with Section 56 by offering lawful consideration or compensation for eviction. This, unfortunately, denies the tenant's legal right and, in effect, turns the courtroom into a rubber stamp for dispossession. Judges quite frequently pass eviction decrees without mentioning or enforcing the compensation clause. They allow possession to be handed over to landlords without requiring lawful payment to tenants. By bypassing tenant rights, despite the mandatory nature of Section 56, this is not just a simple oversight. It actually amounts to a gross miscarriage of justice. Sometimes, judges cite the state of Maharashtra and another versus Supermax International Private Limited to justify awarding mesna profits or interim compensation. But this particular case actually involved commercial premises, not residential Pagri tenants. Courts at times misuse this ruling to sidestep Section 56's compensatory protection, which ends up reducing it to, just an optional courtesy. The victims in all this are, the Pagri tenants who find themselves with nowhere to go. Because Section 56 is just, ignored, tenants are evicted without any market-linked compensation. Even tenants who have lived there for 40 or 50 years are pushed out like, honestly, encroachers. Meanwhile, landlords pocket massive profits, and tenants are left destitute and homeless. The failure of the High Court to rectify these injustices is frankly troubling. Even the High Court upholds trial court decrees without, addressing non-compliance with Section 56. Pagri tenants are treated as if they are just licensees or squatters. The court fails to distinguish between a contractual breach and a statutory violation. So, what does the law demand, and what does justice really require? Courts are bound to frame all relevant issues, especially when protective statutes like Section 56 are involved. A decree that's passed without considering a tenant's statutory rights is voidable, if not outright void. Section 56 is not just a suggestion, it is a legally binding condition precedent to any eviction. In conclusion, there is a real need to restore the law and protect the vulnerable. The deliberate omission or ignorance of Section 56 by small causes and High Court judges is not just some clerical mistake. It is a structural failure that destroys lives and violates the very principle of equitable justice. Judges must be held accountable. tenants have to assert their rights under Section 56, Clauses 1 and 2. And honestly, the legal community must ensure that no eviction is allowed without lawful fair compensation as mandated by the Act.